All right. Superior Court of Fulton County, now the Judicial Service non-session, the Honorable Judge Dr. Maxfield presiding. Court now come to order.
Thank you all. Please be seated. Morning, Stan. Good to go? All right, we are on the record with 23 SC 1888947. Defendant Roman's motion to dismiss and disqualify filed January 8th, adopted and supplemented by several co-defendants. So first, if we could have counsel for the record identify themselves, starting with the state, and then we'll go through the defendants in the listed order. So.
Good morning, Your Honor. I'm Anna Green Cross for the state.
Good morning, Judge Adam Abadi for the state.
Good morning, Your Honor. Andrew Evans for Nathan Williams.
All right, and beginning with from the order of on the notice, beginning with former President Trump.
Good morning, Your Honor. Steve Sadow and Jennifer Little for President Trump, and he waives his presence at the hearing.
Thank you, Mr. Sadow. On behalf of Mr. Giuliani.
Alan Stocks for Mr. Giuliani. He waives his presence as well.
Mr. Meadows.
Your Honor, Jim Durham on behalf of Mr. Meadows.
All right, thank you, Mr. Durham. On behalf of Mr. Clark.
Harry McDougall, Your Honor. Mr. Clark waives his appearance at the hearing.
And let me go back to Mr. Durham. Mr. Durham, does your client also waive his presence as well?
Yes, Your Honor.
Okay. Did I catch that from Mr. Giuliani?
Yes.
Okay. All right, on behalf of Mr. Cheeley.
Richard Rice and Mr. President Willits and our client waives.
Thank you. On behalf of Mr. Roman.
Good morning, Dr. Ashley Merchant and John Merchant on behalf of Mr. Roman and
Mr. Schaefer.
Good morning, Your Honor. Craig Gillen and Anthony Lake for Mr. Schaefer. Mr. Schaefer is present for.
And Mr. Floyd.
Aaron McCullough on behalf of Mr. Ford.
And then we also have Ms. Latham.
Morning, Your Honor. William Cromwell for Ms. Latham. She waives her presence.
And did we get that, Mr. McCullough, also as well for Mr. Floyd? Just making sure. Okay, thank you.
He's here. Though.
Oh, Mr. Floyd is here. Okay, I see Mr. Floyd is present as well. All right.
Your Honor, one more appearance, Sandy Monroe on behalf of the Fulton County District Attorney's Office.
All right. Anyone else present who believes they may need to be on the record or address any issue coming up in the proceeding? Seeing none.
Judge, I'm here, Dave Banks. I've been subpoenaed as a witness, but I also represent Christopher Campbell.
All right. Thank you, Mr. Banks.
Judge Ben will show for Terrence Bradley. We're under subpoena. We'll be waiting in the hall.
All right. And sir, could we have you spell your name for the record?
First name Bimal, last name Chopra.
All right. In terms of just a little housekeeping in terms of presenting the evidence this morning, my thought was as witnesses are called, this being Mr. Roman's motion, that counsel for Mr. Roman would be the first, and any witness that they call, then in order of the listed defendants, there would be the opportunity for additional direct or cross-examination, however you want to characterize it, and then the state on the tail end of that. So with that, we'll turn it over to Ms. Merchant. Is there anything that we would need to take up before calling the first witness?
Judge, we would invoke the rule of sequestration.
All right. So to that end, pursuant to Rule 615, I would ask that any witnesses subpoenaed or expected to testify at the hearing today, that they should remain outside the courtroom until called, and they shouldn't discuss their testimony with any other witness or watch any kind of live proceeding or recording of the testimony until the evidence is concluded or they're excused from being called today. Are there any exceptions to this rule?
None from the state.
Any from the defense?
No, thank you.
Okay, Mr. Abadi.
Yes, Your Honor. And prior to starting any testimony, the state would just like to address, I guess, an housekeeping matter, some issues to the court as relates to what was represented during the previous hearing, as it relates to witness testimony, specifically the testimony of the former law partner of Nathan Wade, that would be Mr. Terrence Bradley, and what the state would like the court to understand and realize is that in preparation for this hearing, and speaking to witnesses and doing the additional research as it relates to the comments that were represented by counsel, specifically counsel for Mr. Roman, Ms. Merchant, that we've been able to determine that the claims that the defendant has asserted and did assert during the last hearing on Monday are not only legally meritless, but are factually unsupported by the statements that Ms. Merchant made to the court. What I would say they're patently false. They are egregious misrepresentations of what is believed that Mr. Bradley would say or even knows. What I would bring to the court's attention in my speaking with the defense counsel for Mr. Bradley, Mr. Chopra, is that anything that any knowledge of anything he would have would be protected under the attorney-client privilege. He would assert that. And that privilege has not been waived by Mr. Wade. More importantly, the representation was made to the court that Ms. Merchant spoke to Mr. Bradley, and that Mr. Bradley represented that he had firsthand knowledge from speaking to the several witnesses that he would be able to impeach with the statements she represented, that there was a relationship prior to Mr. Wade being appointed special prosecutor, and that there was issues with cohabitation that he would be able to directly impeach those witnesses. That is patently false. And speaking with Mr. Chopra, those are misrepresentations that are not true. They are for the purpose of harassment and undue burden to the district attorney. And we'd ask to renew our motion to quash. And the only hearing we should be having to the hearing as it relates to sanctions for the defense counsel's lack of candor that's required by not only statutory law, the professional rules of responsibility, and case law. And we asked that we move into a hearing that is related to the sanctions due to the misrepresentation and flagrant falsehoods that have been spread throughout the world in an effort to affect this case and to keep it from moving forward. With that, Your Honor, that's our request.
So just small matter of housekeeping.
Yes.
All right. Ms. Merchant.
Judge, first, the witnesses haven't been sequestered, so I just asked that they be sequestered before we argue this or have any more argument. I know Mr. Wade is still here. So we just asked that he leave since he is under subpoena.
Let's start there. Mr. Body.
Well, I have to agree when testimony starts that the rules of sequestration would require Mr. Wade to leave, but that we haven't started testimony. It's his argument. He's lead counsel for the case, and he has every right to be sitting at the table.
Okay, Ms. Merchant.
Let's hear from some witnesses. Let's actually hear some sworn testimony under oath. I have made proffers, and it just seems like all we're going to get is objection after objection because the state clearly does not want any witnesses to take a stand, doesn't want the truth to come out from the court. This is a very important issue, and we need to have witnesses. I have a good faith basis. Learn I have a good faith basis, and Mr. Bradley is not my only witness to this good faith basis. It is just happens to be the evidence I proffered at the hearing when the state first tried to keep all of these other witnesses off the stand. I was forced to proffer certain testimony to get over the hurdle to refute their motions to quash. I did that. I used Mr. Bradley's testimony to do that. He is not the only witness that can state that there was a relationship prior to Mr. Wade being hired. The first witness that I'd like to call is Robin Geardy, not Mr. Bradley, no privilege issues. Let's start with her.
Your Honor, when we have additional argument or matters to be brought up, do we want to do it like I just stand up and with relation to what's just been said by Mr. Avante, or are you only hearing from Ms. Merchant at this point? I just need to know the court's protocol.
Sure. So I think at this point, we just need to take these issues one at a time. And as you've joined the motion, I think defense counsel would have the opportunity to weigh in. But again, at any point, if I'm just hearing the same thing over and over again from each separate defense counsel, I'm going to reserve the right to say, thank you.
I appreciate that.
All right.
I only asked for the opportunity for on the invocation of the attorney-client privilege and the burden being on the individual raising the privilege to prove that a privilege in fact was in existence before we get to simply get the claim. That's what I asked.
Sure. Understood. So, Ms. Merchant, I do want to put it back to you, though. The issue raised by the state this morning is that essentially, as I would summarize it, the good faith basis that you did put forward on Monday did not exist, right? So why wouldn't we start with Mr. Bradley and see where we go from there?
Judge, the good faith basis does exist. So you basically have them saying it's not true and me saying it's not true. So they think they have a good faith basis. I think I have a good faith basis. I have a huge good faith basis for everything that I put in every single motion. That's going to come out. The reason I don't want to call Mr. Bradley first is for hearsay objections, quite frankly. And normally we don't have to disclose how we're going to present evidence. I'm okay doing that here, but based on the rules of evidence, hearsay, and privilege issues, what makes the most sense, and we've spent a lot of time thinking about this, what makes the most sense is for us to have Ms. Yeardy testify. And if you want me to proffer what I anticipate she's going to say, I talked to her last night. She's going to say that there was a personal relationship that began in October of 2019. She's going to testify to that. And she has personal direct knowledge of that. It's not hearsay and it's not privilege. She's going to take the stand. She's terrified, but she's going to take the stand and tell the truth. And then I plan on calling Mr. Wade, because at that point, I can overcome their motion to quash and bring Mr. Wade, bring him to come. Then I can go through privilege issues with him, and then I can have Mr. Bradley testify. And we won't have to have an objection to every single question I ask Mr. Bradley, an objection to hearsay, an objection to privilege. So that's how I plan on presenting the evidence, because it makes the most sense. And I think I'll be able to overcome any privilege objections. We can talk about that when Mr. Wade takes a stand.
All right. Mr. Avati, any last words on starting with Ms. Yurdi and going from there, taking it a witness at a time.
I mean, no, but I guess my final response would be that, as Your Honor pointed out during the last hearing, Ms. Merchant's entire representation for good faith was all solely based on Mr. Bradley. In fact, I remember the court saying that the star witness presented or provided by the defense is Mr. Bradley, and you asked a specific question, Ms. Merchant, well, Mr. Bradley, does he have firsthand knowledge from these people, each one of them, you named the lawyers plus the investigators, as it relates to the claims that were made? And her answer was yes. I can definitively tell you the answer is no. And Ms. Merchant has not spoken to Mr. Bradley, according to his counsel, B.C. Chopra, who is outside and can represent to the court the things that I've represented. And he has maintained and represented that everything that she plans to go into or ask is protected by attorney-client privilege. And the only point of this process and this procedure, as it relates to the motions that were filed, is to create a spectacle and to create harassment to the district attorney of Fulton County. And we request that the only hearing we move forward is sanctions for counsel's lack of duty of candor to the court and to counsel.
All right. Well, I think you certainly put her on notice if that is actually the case. But at this point, I have someone saying yes and I have another person saying no. And so I think that conflict in the evidence that we noted on Monday still exists, and that's where we are. And we'll see how the evidence presents itself. So with that, Ms. Merchant, are you ready to call your first witness?
Yes, Judge.
All right.
We call Ms. Yurdi, and I know Mr. Partridge had emailed before, and I quite frankly couldn't keep up about a Zoom, so I don't know if she's on Zoom or if she's going to be here at 9:30. She may be on Zoom, I'm not really sure.
Ms. Partridge, Mr. Partridge was joining us by Zoom, but Ms. Yurdi is here in person, right?
Mr. Partridge, I believe, represented that his client would be more comfortable if he were here in person, and that, due to his conflict in Richmond County this morning, couldn't occur until this afternoon. I think that is a reasonable request, but not the state's business. The witness is here. If her attorney is able to join right now, perhaps that can be something that is addressed with Mr. Partridge in the court. But I want to alert the court that was the representation. The witness would prefer not to go forward without the client present, and that's certainly a reasonable request.
Sure. I think the latest I'd seen, though, that Mr. Partridge was going to be able to join by Zoom.
Okay, great.
I didn't know that he had that Mr. Partridge had affirmed that. That was the email this morning that I missed.
Yeah, I don't know either, but the state seems to know that Ms. Yurdi is here, so I guess she's not appearing by Zoom.
Is Mr. Partridge here?
We'll find out. All right, so just for everyone's information, we did convey the Zoom link to Mr. Partridge this morning. I think the last exchange we'd had is that he can join us by Zoom, and apparently has elected not to do so. So I don't really know what else we can do with that. He was noticed of the hearing, we provided him a link, and we haven't heard from him at all. So I think we need to go forward.
Call Ms. Yurdi.
Your Honor, before we go forward, we have business documents that were certified and filed yesterday evening. about this morning, emailed to Fulton Council yesterday evening. We wanted to make sure that this was part of the record before any testimony is taken or before the proceeding commences this morning.
All right. And so in your mind, this satisfies Fulton County's subpoena in this case?
Correct.
Okay. If you could hand that to Ms. Merchant and we'll take it from there.
Okay, and I don't know, I need to review what they've just submitted to see for this.
I have an original for the court.
Ms. Monroe, if you could just provide it to Ms. Merchant, and if you could just stay on call, we'll let you know if we need you again, okay?
Thank you.
All right. Were we bringing in Ms. Yurdy?
Oh, I'm sorry, I thought the state said that Ms. Yurdy was outside, or they'd seen her or something. So, may John, step out. She's under subpoena to be here at 9:30. May I text her order?
Yeah, and just one of them? What's it?
Tried to call Mr. Parker's judge and it went straight to voicemail and he messaged and said he was speaking with me.
All right. Did he say where his client is? All right. And this is was this a former or current employee of the DA's
Former.
office? Okay.
And her return been filed. I know that she did not want to come without her lawyer here. I said, I instructed them that.
All right. Well, Ms. Merchant, do you have any other witnesses available?
Well, we have Mr. Bradley, have him testify, but again, we're probably gonna have a lot of objections with, privilege, and so I'd much rather call Mr. Yurden first, but I know that Mr. Partridge, they're wrinkling that this morning by having a conflict. So I'm gonna do that.
Sure. So
But I can, what I could do is I could call Mr. Bradley and then I can bring him back.
exactly, I think you can always recall them. We can ping pong back and forth if we need to based on hearsay issues, but at least we can use this time until Mr. Partridge chooses to join us.
Is he on your Zoom? Or not Mr. Partridge or Miss Yurden on Zoom?
No, not that we're aware of.
No, okay, just wanted to check that out.
All right, so
That's the
I
only
suppose
thing
call your next witness then.
All right, we call Terrence Bradley to stand. If we don't hear, and I don't want to have the sheriff take anybody up or anything like that, but if we don't hear from Mr. Partridge within an hour or so, we need to.
Understood.
Thank you.
Thinking, is someone getting Mr. Bradley in?
Yes, I believe so. Oh, the sheriff's gonna go. Okay. Sorry. Normally, sorry. Are the sheriffs, when I call a witness, will the sheriff's not sound for them?
I don't know if they're going to know where they are. So I think it'd be best if maybe someone from your team, and they're not going to know what they look like either.
Not a problem.
Sure.
County judge.
I do.
Terrence Bradley, Terrence Bradley, Bradley.
Your Honor, as Mr. Wade's counsel, before we start, we would request to come to the chambers to talk about attorney-client privilege before we get up to stand.
Why does that need to be in camera?
Doesn't necessarily, well, there's statements that could be made that could be prejudicial depending on whether they were covered or not, whether he's going to break the.
So at the time a question is asked that you think implicates some of those statements, object, and we'll handle it.
Thank you,
Merchant.
Judge.
Just
Thank-
on behalf of Mr. Bradley, and I apologize, this is not our proceeding, but it might be helpful to have a brief sidebar as opposed to something in chambers, at least so that we could let the court know our position rather than having to restate it repeatedly.
And Judge, I've carefully crafted my questions to avoid any privileged information. But if they think that I'm invading that, then I welcome an objection and I'm happy to address it.
Let's see how it goes. And again, Mr. Bradley, I'll ask if you can just give a pause in between each question to allow counsel the opportunity to object before answering.
Thank you, Judge. Was the witness sworn or do I need to swear the
I
witness?
believe he
Okay.
was.
Great, thank you. I'm sorry. Good morning, Mr. Bradley. How are you?
Good morning.
Not happy to be here, I'm assuming.
I am not.
I understand. Thank you for being here.
Wasn't by choice.
Right. You were subpoenaed to come and testify in this case.
I was.
But you and I have spoken previously about relevant facts surrounding Mr. Wade and Ms. Willis's relationship.
No, we have not.
We have not. We've not texted about those facts.
Through a third party, you were given some information. You and I shared text. Our texts were more so about my health, more so about if I was okay with what was going on, that I would not be, whether or not I was going to be subpoenaed or not, and that emphatically I would not have been sitting in this position as being called as a witness. So that's what my text chain show. So no.
That we've never talked about Willis and Wade having a relationship.
Not directly you and I, no. We talked about my health.
Okay.
We talked about, as I stated before, other things, but not this, no.
Okay. Did you text me about Wade and Willis taking many trips together?
I'm gonna.
I object. Well,
Mr. Brown,
sorry.
there's been an objection.
One, I'm gonna object as it relates to attorney-client privilege. Two, I'm going to object because I haven't seen the text message that she's attempting to impeach the witness with. And two, he's made all of his representations is that he's had zero communication as it relates to ask about, and that the only information that she has from him is through a third party, which would be hearsay.
Ms. Merchant.
Judge, it's not hearsay. We've had these conversations. If I need to take the stand, I will. If I need to put my phone into evidence, I will.
So the first objection was to privilege on behalf of the state.
Oh, I'm sorry. I did not respond to
Sure.
that. Thank